Ever wondered what the recent Chamber of Digital Commerce's stance on the SEC versus Kraken case means for the future of cryptocurrency regulation? Well, it's a fascinating story that's been unfolding, and today we're going to delve into the details. In a recent turn of events, the Chamber of Digital Commerce, a Washington-based blockchain advocacy group, filed an amicus curiae document in support of Kraken, a US-based cryptocurrency exchange, in its legal tussle with the US Securities and Exchange Commission, or SEC. The Chamber argued that the SEC's actions raise separation of powers and due process concerns, and that digital assets are not inherently investment contracts. The Chamber, which champions the acceptance and use of digital assets and blockchain-based technologies, contends that the SEC's stance stymies innovation, potentially hindering the evolution of a robust cryptocurrency industry as a key component of the US economy. Contrary to the SEC's broadened definition of investment contract, the Chamber of Commerce asserts that digital assets are certainly not securities, underlining that these are merely lines of computer code. Referencing various legal precedents, it emphasizes that regulation supports this claim, and the idea to identify if a transaction or scheme is an investment contract must be evaluated on a case-by-case basis. The amicus curiae also states that due to its significance in the US economy, cryptocurrency regulation should be subject to the major questions doctrine. This doctrine posits that Congress retains authority over an agency if a case is extraordinary and embodies economic and political significance. The Chamber maintains that blockchain would fall under this doctrine due to its extensive reach and economic significance. This implies that the SEC should adhere to Congress leadership on the matter and halt its regulation by enforcement policies over this burgeoning industry. Coinbase, another US cryptocurrency exchange embroiled in a legal dispute with the SEC, has previously argued that the major questions doctrine should apply to the cryptocurrency industry, stripping the SEC of any authority over the issue until Congress establishes clear regulations. Lastly, the Chamber maintains that even if the major questions doctrine does not apply to crypto as securities regulation, the SEC has failed to provide fair notice with its regulation by enforcement approach, leaving the industry in the dark about whether an asset constitutes a security or not. In summary, the Chamber of Digital Commerce's stance on the SEC versus Kraken case throws into sharp relief the ongoing debate over cryptocurrency regulation. It underscores the need for clarity, fair notice, and a case-by-case approach to defining investment contracts, as well as the potential application of the major questions doctrine to cryptocurrency regulation. Whether or not this stance will influence future regulation remains to be seen. However, it certainly adds a compelling chapter to the unfolding narrative of cryptocurrency's place in our economy.